This exact scenario happens every single day across America. Completely sober drivers make one critical mistake during DUI stops that hands officers exactly what they need for an arrest. And once you make that mistake, your actual sobriety becomes almost irrelevant to the outcome. Here's the trap nobody tells you about. Police officers are trained to use 5 specific psychological tactics carefully designed to make innocent people incriminate themselves. These tactics aren't about accurately determining actual impairment. They're about systematically building probable cause for arrest through your responses, your voluntary cooperation with requests, and your natural confusion about what's really happening legally during the encounter. I've personally analyzed over 400 DUI case files from courts across the country. I've reviewed countless hours of police body cam footage showing these exact tactics being successfully deployed. I've studied the actual police training manuals that teach officers step by step how to manufacture probable cause even when drivers are demonstrably and objectively sober. And through all that extensive research, I've identified the 5 specific tricks that lead to the most wrongful arrests of innocent drivers. I'm going to show you the exact 5 tactics officers deploy during stops, the real legal standards they're exploiting in each specific situation, and most importantly, the precise words and phrases that legally protect you from arrest. This is educational content only for informational purposes. For specific legal guidance about your individual situation, you must consult a licensed attorney in your jurisdiction. Mistake number 1 is answering the drinking question. Picture this scenario. Officer approaches your window. Before asking for documents, he says, "Have you had anything to drink tonight?" Sounds casual. It's calculated interrogation. People think honesty helps. They believe admitting to 1 beer 3 hours ago will show cooperation, and the officer sends them home. That's absolutely not how this works. Legal reality. The moment you admit to any alcohol consumption, you've given reasonable suspicion to extend the stop. That 1 beer, doesn't matter, it was hours ago, you handed them legal justification to detain you longer, demand field sobriety tests, and escalate this into a full DUI investigation. Evidence problem. Body cams record everything. Your admission goes straight into the police report. Prosecutors use that statement to establish you operated a vehicle after consuming alcohol. Defense attorneys call this admission against interest. You volunteered evidence prosecutors use to convict you. Officer psychology. Training manuals explicitly teach asking about alcohol before requesting documents. Why? If you admit drinking first, everything that follows becomes a DUI investigation, rather than a routine stop. The legal threshold changes. They can justify extended detention, multiple tests, aggressive questioning. Exact dialogue. Officer asks, "Have you had anything to drink tonight?" You respond, "I'm not discussing my day, officer." If pushed with, "It's a simple question," repeat, "I'm not discussing my day, officer." If, "Are you refusing to cooperate?" say, "I'm happy to provide license and registration. I'm not answering questions." Why it works. Fifth Amendment protects against self-incrimination. You have zero obligation to answer. Pennsylvania versus Mims lets officers order you from vehicles, but doesn't require answering interrogation. Silence cannot be probable cause. Bottom line, any alcohol admission becomes DUI prosecution foundation. Stay calm, polite, but silent. That protects Fifth Amendment rights. But it doesn't prevent officers observing behavior and appearance. Mistake 2 exploits observations through tests even sober people fail. Mistake number 2 is performing field sobriety tests. You've refused to answer drinking questions. Officer shifts tactics. "I need you to step out and perform some standard tests to make sure you're safe to drive." You think cooperation proves you have nothing to hide. You're building the prosecution case against yourself. People believe passing tests proves innocence. They think walking straight and standing on one leg gets them sent home. Dangerous misconception. Legal reality, field sobriety tests are voluntary. NHTSA research shows walk and turn is 68% accurate. One leg stand, 65%. Horizontal gaze nystagmus eye test, 77%. These tests fail to correctly identify sober people 1/3 of the time. You can be sober and still fail from nervousness, physical limitations, uneven pavement, poor lighting, or the officer's subjective interpretation. Evidence problem. Body cameras capture performance, but not how instructions were given. Whether you could ask clarifying questions, your medical conditions affecting balance, or that the officer administered the test incorrectly. Courts repeatedly found officers deviate from NHTSA protocols. Juries see you stumbling and assume guilt. Officer psychology. Training teaches most people attempt tests if asked. They phrase it as, "I need you to perform tests," making it sound mandatory when it's voluntary. They're trained to look for failure cues. Foot down at 28 seconds instead of 30, failure clue. 8 steps instead of 9, failure clue. They're not clearing you. They're justifying the arrest they've already decided to make. Exact dialogue. Officer says perform tests. You respond, "Officer, are you asking me or ordering me to perform these tests?" This forces clarification, if ordering. For the record, what's the lawful reason for ordering physical tests? I want to comply, but understand the legal basis. Then, I respectfully decline to perform field sobriety tests. I'll comply with chemical testing as required, but I'm declining voluntary physical tests. If asking, I respectfully decline. Why it works. Field tests aren't required under any state's implied consent law. Implied consent applies only to chemical testing after arrest. You cannot be penalized for refusing field tests. Without your voluntary performance, the officer loses significant evidence for probable cause. Bottom line, field sobriety tests are designed for you to fail. Officers aren't clearing you. They're building prosecution evidence. Stay calm. Decline politely. Decline absolutely. That stops physical test evidence. But declining doesn't prevent another probable cause tactic. Mistake 3 involves the preliminary breath test at Roadside. Mistake number 3 is taking the Roadside breath test before arrest. You've declined field tests. Officer pulls out a handheld device. Just blow into this real quick to make sure you're under the limit. You think this clears you. It does the opposite. People confuse two legally distinct tests: preliminary breath test at Roadside before arrest, evidentiary breath test at station after arrest. Understanding this distinction can be the difference between going home or going to jail. Legal reality, Roadside preliminary breath test, called a PAS test, is voluntary in most states for drivers over 21. Not covered by implied consent, used solely to establish probable cause for arrest. Not admissible in court for actual blood alcohol content. It's a screening tool to justify custody. These portable devices are notoriously inaccurate, not calibrated frequently, can produce false positives from mouth alcohol, mouthwash, acid reflux, or cold temperature. Evidence problem: officers use PAS results to claim probable cause. Even at 0.03, well below 0.08 legal limit, the officer writes subject registered positive for alcohol. Prosecutors use that language to argue impairment. The actual number might not be admissible, but the fact you tested is. Officer psychology. They make PAS sound mandatory. I need you to blow, or state law requires breath test. Both misleading. State law requires breath testing after lawful arrest under implied consent, not preliminary roadside screening before arrest. They bank on your confusion. Dialogue. Officer demands you blow. Ask, is this preliminary screening or evidentiary test after arrest? Forces clarification, if preliminary. I respectfully decline preliminary testing. I understand I'm required to submit to chemical testing after lawful arrest, and I'll comply. If he threatens consequences, implied consent applies to post-arrest chemical testing, not preliminary roadside screening. I'll comply with legal requirements after arrest. Why it works. Most states differentiate voluntary preliminary tests from mandatory post-arrest tests. California Vehicle Code 13353.1 clarifies this. Nevada Revised Statutes 484C.160 confirms. Texas Transportation Code 724.011 codifies. You cannot be penalized for refusing preliminary tests. Bottom line, roadside breath test before arrest is a trap. Cannot help. Only hurts. Decline clearly and wait for mandatory test if arrested. That prevents roadside breath results, creating probable cause. But even protecting yourself from questions, refusing field tests, and declining preliminary breath testing, officers have another tactic. Mistake 4 is where people who followed all the right steps suddenly hand everything over. Mistake number 4 is consenting to vehicle search. You've done everything right so far. Officer is visibly frustrated. He shifts tactics. Do you mind if I take a quick look in your vehicle? If you've got nothing to hide, this'll only take a minute. People consent believing refusal implies guilt. They think saying no makes them look suspicious. Officers count on this. Legal reality. Officers need consent, probable cause, or search warrant. If they had probable cause, they wouldn't ask permission. The question reveals they lack legal grounds. Your refusal cannot create probable cause. Rodriguez versus United States makes this clear. Officers cannot extend stops to search without reasonable suspicion of criminal activity. Asking consent bypasses constitutional protection. Evidence problem. Once you consent, anything found is admissible evidence. That includes items not yours. Friend left something. Previous owner left something hidden. Medication looks suspicious. Consent turns routine stop into fishing expedition where officers search for anything to arrest you. Officer psychology uses time pressure and social engineering. They ask casually, "You don't mind, right?" Or, "Just take a second." They make refusal seem unusual. They continue asking after you say no. "Are you sure? What are you worried about?" Intentional intimidation to wear down resolve. Exact dialogue. Officer asks to search vehicle. 9 words. "I do not consent to searches, officer." If, why not if nothing to hide? Repeat, "I do not consent to searches. I'm exercising Fourth Amendment rights." If threatens K9, "I do not consent to searches, and am I free to leave?" This final question is critical. Rodriguez established officers cannot extend stops for drug dogs without reasonable suspicion. Why it works. Fourth Amendment protects against unreasonable searches. Courts held refusal cannot be probable cause basis. Without consent, officer needs specific facts creating probable cause. Much higher legal standard than asking permission. Bottom line, never consent to vehicle searches during stops. Cooperation doesn't mean sacrificing constitutional rights. Stay calm, polite, but absolutely refuse. That protects Fourth Amendment rights during the stop. But even handling everything perfectly at roadside, officers have one final tactic after arrest. Mistake 5 is where people lose entire defense before seeing a lawyer. Mistake number 5 is answering post-arrest questions without a lawyer. You're arrested at the station. Officer seems friendly. "Look, I'm just trying to figure out what happened. If you explain your side, we can clear this up." You think honesty helps? It destroys your case. People talk believing explaining innocence leads to release. Make the officer understand you weren't drinking, he'll let you go. That's not how this works. Arrest already happened. Officers aren't investigating whether to arrest. They're building prosecution's case. Legal reality. Miranda rights apply once in custody and interrogated. But people don't understand. Miranda only matters if you invoke it. Berghaus versus Tompkins ruled simply remaining silent isn't enough. You must explicitly invoke rights. If you sit silent but don't invoke, eventual statements are admissible. If you talk without invoking, everything is admissible. Evidence problem. Post-arrest statements become prosecution centerpiece. You say, "I only had 1 beer 3 hours ago." Prosecutors establish you operated vehicle after consuming alcohol. They bring toxicologists to testify 1 beer means measurable blood alcohol. They argue if you're lying about quantity, you were more impaired. Everything becomes ammunition. Officer psychology gets sophisticated. They're trained in interrogation. They minimize. This happens all the time. They suggest cooperation helps. Judge looks favorably on honest people. They imply they're helping. Just trying to help you here? None true. Prosecutors use every word to maximize charges. Exact dialogue. Officer starts questioning after arrest. Immediately say, "I'm invoking my right to remain silent and I want an attorney." If you're not under arrest, just talking, ask, "Am I free to leave?" If no, repeat, "Then I'm invoking right to remain silent and I want attorney." If attorney can't help now, say, "I'm invoking right to remain silent and I want attorney." Repeat this exact phrase no matter what. He might try 10 approaches. Your response never changes. Why it works. Once you invoke both rights, questioning must stop. Miranda versus Arizona established this. Edwards versus Arizona reinforced it. If officers continue after you invoke, statements are inadmissible. Protection is absolute. Bottom line, post-arrest. Your only response is invoking rights and requesting lawyer. Stay calm. Stay silent. The core principle connecting all 5 mistakes. Building DUI cases is a process, not a single moment. Officers systematically need your cooperation, your voluntary statements, and your test performance to establish probable cause and secure conviction. Every single time you refuse to provide evidence against yourself, you force them to rely on objective, observable facts rather than your voluntary admissions and cooperation. The 4 critical phrases you must memorize. 1. I'm not discussing my day, officer. 2. I do not consent to searches. 3. I respectfully decline field sobriety tests. 4. I'm invoking my right to remain silent and I want an attorney. Print these exact phrases out. Practice saying them out loud, repeatedly until they become automatic. Because in the high-stress environment of a traffic stop, your brain won't think clearly. But if you've practiced these phrases beforehand, they'll come out naturally. This is educational content only, not legal advice. Always consult a qualified attorney in your state for your specific situation. If this helped you understand your rights during DUI stops, hit that like button. Subscribe to the channel for more legal education content that protects you during police encounters. Click the bell icon for notifications when I post new videos. And share this with anyone who drives because these exact tactics are being used on innocent people every single day across the country. You just learned how to protect yourself during the stop itself, but understanding what happens during arrest is only part of your complete legal education. There are other constitutional protections that apply at different stages of DUI investigations and different legal standards that kick in depending on the specific circumstances. I cover those other critical protections and the exact timing of when to invoke each right in the next video. It's on screen right now, don't skip it. It completes your comprehensive legal framework for DUI encounters. Constitutional rights only protect you if you actually know how to invoke them. Most people don't know. That's why innocent drivers get arrested, charged, and convicted every day. You now have the knowledge to avoid that outcome. Stay informed. Stay protected. And remember this final principle: cooperation does not mean conversation.